Good morning. The committee will come to order. Without objection, the chair is authorized to declare recess of the committee at any point. Without objection, do we have any members being waved on or no? No, okay. I will now recognize myself for an opening statement. Thank you to our witnesses for coming to participate in this important hearing. It's our third addressing ongoing attacks on freedom of speech in America. Our first two focused on the assault on freedom of speech on campus, in schools, K through 12, as well as in colleges. We examined a nationwide push to ban books deemed politically or ideologically incorrect and censor the expression of students, teachers, and families in the classroom, a trend which unfortunately shows no signs of abating as we begin the new school year. Today, we turn our attention to the multi-pronged effort by the fossil fuel industry to attack its opponents and silence environmental activists through the strategic deployment of civil litigation, specifically so-called SLAPP suits, strategic litigation against public participation. SLAPP suits come in many forms: civil suits alleging defamation, libel, slander, tortious interference with contract, and even allegations that individuals or groups are engaged in a corrupt racketeering enterprise under RICO. For example, Energy Transfer Partners, the company that's building the Dakota Access Pipeline and which made $66 billion in revenues in 2021, alleged that environmental nonprofits and other activists were engaged in criminal racketeering violations against the company. Its claim was that the defendant's First Amendment protected activities, such as organizing, talking to neighbors, communicating with people online, sharing information, and protesting against pipeline construction, constituted predicate acts sufficient to trigger RICO Act liability and cause the award of millions of dollars in damages. After several years and millions of dollars spent in litigation by the defendants, the case was simply thrown out of federal court as meritless. But great damage was done in the meantime to the groups and individuals sued through the staggering time and financial and emotional and political costs of having to defend against a meritless but overwhelmingly difficult lawsuit. To make matters worse, after its case was thrown out of federal court, Energy Transfer simply refiled the same claims in state court, creating essentially another RICO case that's still ongoing today. Similarly, Exxon invoked a rarely used Texas law to try to depose city officials from California in an apparent effort to set up another SLAPP RICO case after several municipalities sued for damages related to the rise in sea levels. Again, after several years of litigation, the case was rejected by the Texas Supreme Court for lack of personal subject matter jurisdiction. But in the meantime, the damage was done with these strategic efforts to discourage and to punish citizens just for exercising their First Amendment rights. Wealthy and powerful corporate entities are dragging citizens and public interest opponents through meritless but protracted and extremely costly litigation to expose anyone who dares to stand up to them to financial and personal ruin. In its work to silence its critics, the fossil fuel industry is also pushing for the passage of anti-protest laws dressed up as critical infrastructure protection statutes, and we're going to hear about these. The first of these laws was passed in Oklahoma in 2017 with the explicit purpose of punishing pipeline protesters. While the state already had criminal penalties for trespass, vandalism, destruction of property, and tampering, the new law created draconian penalties for the exact same crimes in the vicinity of critical infrastructure, such as terms of up to 10 years in prison for vandalism or defacing property. Under that law, individuals and groups could be fined or sued for tens of thousands of dollars for involvement even in lawful activities like letting a critical infrastructure protester stay in your home or camp on your property. Since that time, 16 states have followed with substantially similar or identical statutes which dramatically increase civil and criminal penalties for what would otherwise be misdemeanor civil disobedience offenses like disorderly conduct or clearly First Amendment protected activity like rallying and chanting and taking a position on a public policy question. Ann Whitehat, an indigenous water protector, who we are going to have the benefit of hearing from today, was subjected to one of these critical infrastructure laws. In Louisiana, where she was apprehended by law enforcement officers who were moonlighting on the fossil fuel industry's payroll. As private officers, she faced up to 5 years of hard labor for the crime of trespass. This is despite having been permitted to be on the land that she was removed from by the landowners. It's crucial that Congress protect the rights of American citizens and civic groups to engage in lawful political protest from whatever political perspective without being subjected to ruinously expensive and meritless retaliatory litigation. Presently, 30 states have, in a bipartisan manner, adopted anti-SLAPP laws to protect citizens from baseless lawsuits. However, 18 states don't have these laws in place, and there has never been a federal anti-SLAPP law. In the coming days, I hope to introduce a strong federal anti-SLAPP corollary, and I hope my friend Ms. Mace and friends on both sides of the aisle will join me in our efforts to end the chilling and punitive practice of stifling and discouraging civic action by the people of the United States. I look forward to hearing from our witnesses today, and with that, I'm happy now to recognize the very distinguished ranking member, Ms. Mace, for her opening statement.